There's a letter that lands on thousands of UK driveways every single week, and the moment it arrives, a clock starts ticking that most drivers have absolutely no idea about. One that can end with 6 automatic points on your license even if you did nothing wrong the day the original offense happened. Today we're breaking down exactly what that letter is, why the window to respond is so much tighter than people assume, and what you genuinely need to do the second it lands on your mat. We're talking about the Notice of Intended Prosecution, commonly shortened to a NIP, and it's one of the most misunderstood pieces of post a driver can receive, precisely because it doesn't look particularly alarming on the outside. It gets triggered by a range of common offenses: speeding caught on camera, running a red light, using a mobile phone while driving, careless driving, or failing to stop after an incident. Under Section 1 of the Road Traffic Offenders Act, 1988, the police are required to get this notice to the registered keeper within 14 days of the alleged offense, specifying what happened, where, and when. That's the first deadline, and it belongs to the police, not to you. Here's where your own clock starts, and this is the part that catches so many people completely off guard. Attached to almost every NIP is what's called a Section 172 request, a legal requirement for you as the registered keeper to identify exactly who was driving the vehicle at the time of the alleged offense. You have 28 days to respond. Not 28 days to argue your case, not 28 days to decide whether you agree with the original allegation, simply 28 days to confirm who was behind the wheel. Miss that window, and you haven't just lost the chance to contest the original offense, you've committed an entirely separate criminal offense in its own right, one that carries 6 penalty points and a fine of up to £1,000, regardless of what the underlying speeding or phone offense would have carried on its own. Now here's why that 28-day window is genuinely shorter than it looks on paper. Almost every police force sends these notices by first-class post, and the law treats a first-class letter as deemed served 2 working days after it was posted, whether or not it actually reached you on that exact day. So if a notice is posted on the 1st of the month, it's legally considered received on the 3rd, and your 28 days is counted from that deemed date, not from whenever you actually happen to open your post. If you're away for a week, if the letter sits unopened in a pile of junk mail, if it goes to an old address because your details weren't updated, none of that pauses the clock. The countdown started the moment the law says it started, regardless of your actual awareness of it. This is exactly why keeping your address current with the DVLA isn't just a box-ticking exercise. It's the single biggest practical protection you have against this entire process. If your registered address is out of date, the notice still gets treated as properly served the moment it's posted to whatever address DVLA has on file, correct or not. There are documented cases of drivers being convicted and even disqualified, entirely unaware proceedings were happening, because letters were going to an address they'd moved out of years earlier. An out-of-date address doesn't excuse you from the deadline, it just means you find out about the deadline after it's already passed. Most police forces will send a reminder notice, usually landing around 7 days before the 28-day deadline expires, often with a duplicate copy of the original, in case the first one genuinely went astray. But this reminder isn't guaranteed, and it isn't a legal requirement. It's simply common practice that some forces follow more consistently than others. Treating a reminder as a safety net you can rely on is exactly the kind of assumption that leaves people scrambling in the final day or two once they realize how close they actually are to the deadline, which is precisely where a genuinely tight window can start to feel like hours rather than weeks. Let's talk about what actually happens if you do respond correctly and on time. If you were the driver, you simply confirm that in the response section, and the police then decide how to proceed, whether that's a fixed penalty offer, a speed awareness course if you're eligible and haven't done one recently, or in more serious cases, a court summons. If you weren't the driver, you nominate whoever was, providing their full name and address to the best of your knowledge. That person then receives their own Notice of Intended Prosecution in their name, and the 28-day clock starts again for them specifically. It's worth noting that responding on time and correctly doesn't automatically mean the original allegation disappears or gets treated leniently. Identifying the driver is a completely separate legal obligation from whatever happens next with the underlying offense itself. You can respond promptly, confirm exactly who was driving, and still end up facing the full penalty for the original speeding or mobile phone offense. The 28-day requirement exists purely to establish who the police need to deal with, not to offer any leniency on what they're dealt with for. Treating a prompt response as a way of avoiding consequences entirely is a common misunderstanding, and one worth clearing up before it leads to unrealistic expectations about how the rest of the process unfolds. Here's a genuinely tricky situation worth understanding properly, because it trips up a lot of families and small business owners. If multiple people regularly use the same vehicle, and you genuinely can't recall who was driving on a specific date at a specific time, "I can't remember" is not treated as a valid response on its own. The legal standard is that you must make reasonable and diligent inquiries to establish who was driving, checking calendars, asking family members, reviewing work rotas if it's a company vehicle, before concluding you genuinely cannot identify the driver. Simply shrugging and writing "not sure" without demonstrating you actually tried is very likely to result in prosecution for failing to identify the driver, with the courts historically taking a fairly strict view of what counts as a good enough effort. There's also a scenario worth flagging if you lease or hire the vehicle in question, or if it's registered to your employer. In these cases, the first notice often goes to the registered keeper, which might be a leasing company or your employer, rather than you directly. That organization is then obligated to identify who was responsible for the vehicle at the time, which can mean you personally receive your own notice of intended prosecution later than the original 14-day window, sometimes weeks after the actual incident. That delay doesn't invalidate anything. The notice can still be entirely legally valid, even though it arrived well outside what feels like a reasonable time frame, precisely because the clock resets each time responsibility genuinely passes to a new party in the chain. It's worth understanding what actually happens if you simply do nothing at all, because the process doesn't just quietly disappear. If the police don't receive any response within the 28 days, most forces will check the vehicle's insurance details through the motor insurance database, since that record often names the policyholder and any listed named drivers, which can sometimes help identify who was behind the wheel, even without your cooperation. Beyond that, the matter typically escalates to a summons for failing to identify the driver, dealt with either through a postal requisition with a fixed hearing date, or increasingly through the single justice procedure, where you're given 21 days to enter a plea in writing rather than attending court in person. Either route still results in the same 6 points and financial penalty if the court finds against you, so ignoring the process entirely doesn't make it go away, it just moves the decision out of your hands and into a courtroom. If you're convinced you should have a defense, whether that's a genuine belief the notice was never properly served, an error in the details of the alleged offense, or a legitimate reason you couldn't identify the driver despite real effort, the crucial thing to understand is that you still have to respond within the 28 days regardless. You don't get to simply ignore the notice because you plan to argue about it later. Even if you intend to challenge every part of what's being alleged, the Section 172 requirement to identify the driver still has to be satisfied within the window, and any defense you're building gets argued afterward, not instead of responding on time. It's worth understanding the wider consequence of accumulating points here too, because 6 points from a failure to identify offense doesn't exist in isolation. Under what's known as the totting up procedure, once your license reaches 12 or more points within a 3-year period, you're facing a mandatory minimum 6-month driving ban, regardless of how those points were individually accumulated. 6 points from a missed 28-day deadline sits on your license exactly the same as 6 points from a genuinely dangerous piece of driving, and it counts toward that total in precisely the same way. For a driver already sitting on 6 or more points from previous offenses, missing one NIP response deadline can be the difference between keeping a license and losing it for half a year. So let's bring this together into something you can actually act on. If a letter arrives from the police referencing an alleged driving offense, open it immediately rather than setting it aside, because the 28-day window is already running from the deemed service date, not from when you get round to reading it. Confirm your address is current with the DVLA today if you've moved recently and haven't updated it, because an out-of-date address doesn't pause the clock, it just delays when you find out the clock started. If multiple people use your vehicle, actually make the effort to check who was driving on the specific date given, rather than guessing or assuming, because a half-hearted attempt at identification is unlikely to hold up as a genuine defense. And if you're ever uncertain about how to respond, get advice within days of receiving the notice, not in the final 48 hours when your options for a considered response have essentially disappeared. It's worth stepping back for a moment and understanding why this particular process trips up so many otherwise careful drivers, because it's rarely about people deliberately ignoring the law. It's the combination of a genuinely short window, a deemed service rule that starts the clock regardless of when you actually open your post, and a general assumption that a driving offense notice works the same way a parking charge does, where a bit of delay in dealing with it rarely matters. This process doesn't work that way. There's no informal grace period, no 48-hour buffer, no quiet extension if you're a few days late because life got in the way. The 28 days is the 28 days, and the consequence for missing it exists entirely independently of whatever the original alleged offense actually was. It's also worth remembering that this sits alongside a growing number of other automated and camera-based enforcement systems we've covered before. Average speed cameras, mobile phone detection units, ANPR insurance checks, all of which can be the actual trigger that generates the original Notice of Intended Prosecution in the first place. As camera coverage expands, more of these notices are being generated automatically, without an officer ever physically stopping you, which means more drivers are encountering this 28-day process for the very first time, with no prior experience of how tight and unforgiving it actually is. None of this is designed to make a simple speeding ticket feel like a legal crisis. The overwhelming majority of these notices get responded to correctly and result in exactly what you'd expect: a fixed penalty, points on your license for the original offense, or a course you attend and move on from. But the drivers who end up with an extra 6 points and a fine on top of whatever they were originally facing are almost always the ones who assumed they had more time than they actually did, or didn't realize the DVLA needed their current address to make any of this reach them properly in the first place. Updating your address takes about 2 minutes online, and it's genuinely one of the few things on this entire list that costs nothing and closes off an entire category of risk in one go. If this cleared up exactly how tight this process really is and what you need to do the moment a notice lands, hit subscribe, because I'll keep breaking down the deadlines and processes that catch UK drivers out without them ever realizing the clock had started. Stay safe out there, and I'll see you in the next one.